The Trump administration is back on their sanctuary city bullshit, so it is time to talk about the 10th Amendment and anti-commandeering doctrine. Interpretation of this amendment has fluctuated over time, but judicial precedent over the past 3 decades plus has embodied what is called anti-commandeering doctrine. This means the federal government cannot compel a state government to enforce a federal regulatory program. In Prince versus the United States, famously conservative Justice Antonin Scalia said, "The federal government may neither issue directives requiring the states to address particular problems, nor command the state's officers to administer or enforce a federal regulatory program. Such commands are fundamentally incompatible with our constitutional system of dual sovereignty." Dual sovereignty, it means that the federal government has some powers, which are specifically laid out, and the rest of the powers, such as policing, are reserved to the states. However, where there's a conflict, the Supremacy Clause declares that federal law is the supreme law of the land. In regards to immigration, for example, this means that states cannot make laws regarding citizenship. It is a federal crime to knowingly or recklessly harbor, conceal, or shield from detection an undocumented immigrant. So to be clear, this is not what sanctuary policies are designed to do. Anti-commandeering doctrine was refined even further in 2018, where the court held that it is unconstitutional for the federal government to withhold congressionally obligated funds from states who refuse cooperation. Moreover, it is unconstitutional for the executive branch to unilaterally make decisions about the dispersal of federal funds. Congress explicitly holds the power of the purse. The Trump administration is once again threatening quote-unquote sanctuary cities, and this coercion is directly counter to the anti-commandeering doctrine. While doctrine is not law, judicial precedent is not law, the modern judicial perspective has sided with states' rights. Sanctuary city policies, therefore, simply formally enshrine the concept of dual sovereignty that inherently exists in the Constitution. State governments are not and cannot be compelled to use their resources to help enforce federal immigration law. More than that, complying with certain federal immigration policies would require unconstitutional actions by the state. A great example is immigration detainers. This is where DHS asks pretty please for municipal detention centers to hold suspected undocumented immigrants beyond legal limitations until ICE or CBP can get there, which is a violation of the individual's Fourth Amendment rights. So in this way, sanctuary city policies are more in line with American and constitutional values than the state-level laws that ban such policies. All of this is to say that the president cannot compel states by any means, including intimidation, force, or withholding of funds, to cooperate with ICE, CBP, or any other immigration enforcement activities. We know by now that the administration does not believe itself to be beholden to the Constitution, but this is another fight they are going to have to take all the way to the top.